first virtual seminars. So we're working out some loose ends, but I think so far so good. My name is Sarah Bracken. I'm the branch manager of the Akron and Canton locations for Ohio Catholic or OC Federal. Tonight we have a few speakers. First we have attorney Nicole Phelan, Joel Harvey, who is VP, and correct me if I'm wrong, of Life and Long-Term Care for Ash Brokerage. We have Michelle Brooks, who's Ohio CU Financial's financial consultant, and Kelly George, who is head of Ohio CU Financial Division with OC Federal. We do have time at the end for questions. If you want to type them in the chat, we can watch that, or if you can write them down at the end, we'll allow for time at the end for everyone's questions to be answered. Thank you guys so much for coming. Again, we really appreciate it.
Hello, my name is Kelly George, and I'd like to welcome you to the seminar. I'm the manager and sales manager of Ohio CU Financial Service, and I'd like to give you a little bit about my background. I've been in the industry for over 30 years. I have a background working with credit unions. I'm a licensed agent and an investment advisor who's accredited investment fiduciary, and I'm really happy about this opportunity to work with the program. And I want to let you know about the management here, that they care about you, that they would bring a program like this in-house. So Ohio CU Financial Services is not an outside firm. It's the credit union's own program. And I want to give thanks to Todd Taylor, the CEO, and Bill Nelson, the VP, that had the vision to bring a program in-house to help the members. And I can tell you, we can help you with retirement planning and education products like services like this right now, talking about estate planning, talking about preserving your assets for the next generation. So a program like this is unique because it's owned by the credit union, and the credit union realizes that they need this service. And we want to help the members. Our goal is to educate you so you can make informed decisions. And if you need our assistance, you can turn to the credit union. But we're building this program, and we want it to last years from now to help credit union members. So that's what it's all about, is just to help the members and provide the services for them. But I'm looking forward to the seminar, and I can tell you, from my experience, a little bit of planning goes a long way. And I've experienced over my career. One of the first things that when I'm talking to folks, I ask them, do they have their legal house updated? And a lot of folks don't. And unfortunately, I've experienced people not having a little plan in place and the consequences of it. And also, I've heard the credit union was mentioning that there were other, members who unfortunately didn't have a plan in place, and the outcome and the difficulties for the family. So, we want to kind of help people and educate them, but there's going to be other workshops, Medicare, retirement planning, and it's all about education. And we hope that you'll turn to us if you do need help or provide additional services. And with that, I want to turn it over to Michelle Brooks. She's a financial consultant. She helps me. We work together, and she can talk about the other services that are available. Thank you.
Thank you very much, Kelly. As Kelly said, my name is Michelle Brooks. I've been working here at the credit union for about a little over 6 months now, assisting Kelly with getting everything set up for the financial division. What we've been working on is just helping our members figure out ways to expand into, like Kelly said, plan for the future. We have many different products, from annuities where, we can ensure that you will never outlive your income. So to make sure you're set up for the rest of your life. We also have been working on the financial portion to set it up for the future for mutual funds, retirement planning, as well as Medicare services. So with annual enrollment coming up, we are trained at every branch where we should be able to help you with signing up for Medicare, and also for any kind of review if you are unsure or any of your situations have changed and you need a Medicare review. We would be able to help you here at any branch. as well as we are now ready to go for life insurance. So if you do need either a life insurance review or to sign up for life insurance, we do have those products here at OC Financial now and would be able to assist at any of our local branches. So that's where my portion is. With that said, I would like to introduce Nicole Phelan to come on. She is the attorney and she has her presentation to go ahead and start.
Thanks, Michelle. So just so you can put a name to a face, my name is Nicole Phelan, and let me just get my presentation here. Michelle, are you able to see that?
I don't see anything, no.
Okay, hold on. Let's see. There, can you see that now?
Yes, perfect.
All right, let me blow this up and just, I want to make sure you can still see it. Still good?
We can see it, it's just not blown up yet.
Okay. Is it better if I leave it like this?
It's a little small from where I'm sitting.
Right. This is the biggest I can get it.
I wonder if that would do it.
Screen, it's not.
But it's viewing my, oh, I wonder if that would work. Yeah, let's see. Nope. Oh, there we go. I don't know what that did. That did not do what I wanted it to do, though. 'Cause I'm not the one. So I am the one sharing? I thought I wasn't sharing. Why am I the one sharing? Oh, perfect. That looks so much better.
Okay. All right, so like I said, my name is Nicole Phelan. I was born and raised in Fredericktown, Ohio. I went to Mount Vernon Nazarene University for undergrad and majored in philosophy pre-law and minored in business, and then I attended Capital University Law School. This is my family. So obviously for me, it would be the right side, my daughter Isla, my son Walker, who is almost a year, and I'm very sad about it. And then my husband Jared, and you see a tractor in the background. We live on a farm. That was my background. I came from a farm, so we're very much involved in that. This is an actual picture of our farm. We raise beef cattle, we raise sheep, chickens, ducks, we row crop, we make hay. So just a little bit of everything. We're definitely not bored. So my areas of practice, because farming is my background, I typically do a lot of agricultural law. And within that is business and family farm succession planning. That includes business law, elder law, so like your Medicaid asset protection trust or planning for Medicaid, estate administration, otherwise known as probate, estate planning, so like your wills, trusts, POAs, landlord tenant law, and then real estate law. So I'm here to talk to you about estate and legal planning, the importance of that, and it's not to say something's going to happen to you. It is to give yourself peace of mind give your loved ones peace of mind, and provide for a smooth transition to the next generation. So, does anyone know what estate planning is?
You should have told her screens are not sharing on her sidebars.
Tell her that her screen is not sharing.
She's been going down those small
Down on the
pictures, but you
screen.
can't see those.
Oh, okay.
I don't think she's sharing.
Nicole, are you sure you're sharing your screen?
Yep, I am. Let's see.
There you go.
Can you see that?
Yes, now we can see it.
Yes.
Okay. So I'm going to go back so you guys can see. Okay,
There we go.
perfect. All right, so going back, that is my family. This is a picture of our farm. And then to jump where I was, so estate planning. So estate planning is planning for incapacity and death. So within the incapacity area, you need a financial power of attorney, a healthcare power of attorney, and living will. Does anyone know what happens if you don't have a power of attorney? So what happens is a court guardianship. So the significance of a financial power of attorney is you're appointing someone who you choose to make financial decisions for you in the event you cannot make those decisions. So with a financial power of attorney, you can appoint people jointly, you can appoint people individually, you can appoint people jointly or either of them severally, meaning they can act together or they could act separate. A power of attorney for financial can be durable, which means it goes into effect the day you sign it, or it could be springing, which means it only goes into effect upon incapacity. Here lately, I've been drafting a mix of both. So typically parents want it or spouses want it durable to each other, so it goes into effect immediately, but only springing or upon incapacity to children or to their next agent. A healthcare power of attorney, same thing. It is over healthcare decisions. So, whoever, if you're in a hospital bed incapacitated, they can consent to surgeries, medications, DNR, moving you to a facility, whether it's a long-term care facility or rehab. And then they also have the ability to make the decision to take you off of life support. In your living will, which is another document to plan for incapacity, that is you making the decision to be taken off of life support in the event you don't want to be on a ventilator for the rest of your life. So how they work together, in a healthcare power of attorney, you initial box that gives authority to your agent. But if you execute a living will, that living will overrides your agent or overrides your healthcare power of attorney. You take that decision away from them. You've already made it within your living will. You don't have to have a living will. It is a preference document, so it is entirely up to you. So going to court guardianship. So if you don't have any of those documents, then someone would have to petition the court to either be the guardian of your estate, of your person, or both. It may not be someone that you want to be your guardian. It is entirely up to the court. That person is required to get a background check. They are required to be bonded. They are required to go through a 6-hour training every year and then a 3-hour training every year after that. And ultimately, it may not be who you want to. So if you have some rift in your family and you've got multiple people wanting to be your guardian, again, maybe some people you don't want to be your guardian, it's ultimately going to be up to the court. So it is very, very important to execute that POAs while you still can to appoint who you want. I've had recently a lot of people, call me and say, hey, mom's, been diagnosed with dementia or Alzheimer's. Can we execute these POAs? The answer is no. The answer would be yes, if in fact a doctor could provide me a letter stating she has capacity to understand these documents to execute them. I am very strict on, hey, if you don't have capacity, you can't sign these documents. I've got to have proof that you have capacity, which is typically by a doctor. And usually when I hear, well, they've officially been diagnosed with dementia or Alzheimer's, I can't go forward with those documents. And I don't ever see doctors signing off or sending me a letter that says they have incapacity. So instead of pushing these things off, it is better to do them now while you're healthy, and instead of waiting until we're about to have a surgery or whatever the case might be. Next is planning for last affairs. So we talked about incapacity. Last affairs would be planning for the disposition of our estate. Where's our estate going upon our passing? So you can either have a last will and testament, or you can have a living trust. That could be a revocable trust or potentially an irrevocable trust, which we'll talk about. A last will and testament, it becomes public once you pass away. There is a revised code in the statutes that say if someone knows of a will, they have to file it for record only. It might not be probatable, which means there might not be any assets having to go through probate, but regardless, it has to be put on record if someone knows about it. Well, if I drafted it, I know about it, I have to put it on record. Terms go into effect with that will upon your passing. Must go through the probate process if you don't have beneficiaries listed on your assets. So this is excluding personal property such as household goods, meaning that personal property is not probatable in the state of Ohio. So let's run the scenario. You have beneficiaries on all of your assets. The only thing left is what's in the house. No titled assets. There's jewelry, there's clothing, there's kitchen appliances, there's anything like that. Those don't have to be probated. So we file the will for record only, and then those would be dispersed to whoever you put in your will. And then also in that last will and testament, if we have minor children, it allows you to appoint a guardian for your minor children. So in the event something happened to you and your spouse, or to that person's or to that child's, parent, we can appoint someone to take care of our kids if in the event that were to happen. So I'm talking about putting beneficiaries on assets. So ways to avoid probate with certain assets. It's a little different for each one of these. For real estate, you can do so with what's called a transfer on death designation affidavit. So typically in a spouse situation, I say, let's make sure that real estate is survivorship. So you can have husband and wife on a deed, but if it does not have the special language, which is for your joint lives, remainder to the survivor of you, then it's not survivorship. If it has that language, it is survivorship. The significance of that language is in the event one spouse passes first, the other spouse would go to an attorney, would bring a death certificate, we would file an affidavit with the county recorder's office, and it would transfer to surviving spouse. Outside probate court, very simple, very quick process. Then to follow that up, if both of you were to pass in a common accident, or if you're just a single person, we would execute what's called a transfer on death designation affidavit. And then you would list a beneficiary on your real estate. Upon your passing, I would need a death certificate. I would have to write a letter to the Ohio Department of Medicaid to make sure that there is no lien or claim out on your real estate. As long as they say, nope, there's no claim, I file that affidavit with the county recorder, and it transfers to beneficiary outside probate court. Very quick process. For passenger vehicles, there is a law in the state of Ohio that says a surviving spouse can take up to any number of passenger vehicles as long as the collective value is $65,000 or less. So if you have if it's a spousal situation, as long as our vehicles are under $65,000, spouse passes, we're fine. Spouse goes to the BMV with a death certificate, we get those titles transferred over. However, I like to plan for worst case scenario. In the event both of you were to pass in a common accident, your children, your next of kin, your heirs, they are now probating those passenger vehicles. So typically what I'll tell people for any titled asset, whether that's passenger vehicles or boats, trailers, RVs, anything else titled, let's change title to both of you in survivorship, and then let's fill out a beneficiary designation form with the B&B that points a beneficiary. So that would cover in the event spouse passes or only one spouse passes, and then if both spouse pass, then it would go to our beneficiaries. The hardest part with changing it to survivorship is that you have to go to the B&B, you've got to renew your tags, you've got to get new license plates. So yes, it is a big deal and it's a lot to do now. However, it is worth it in the end because now you're not putting your heirs, next of kin, children, whomever else through that process. Bank accounts, life insurance, retirement accounts. Simply all we need to do with those is put beneficiaries on the accounts. If it's a single account, we put maybe spouse first, and then we put kids as secondary beneficiaries. If it's a joint account, we put kids as beneficiaries, or whatever case or facts you have. Business interest, if it's like an LLC, we can make your membership interest transfer on death within the operating agreement. And if it's a corporation, we can put a transfer on death language on that stock certificate, so we can avoid probate with both of those. Outside stock, bonds, savings bonds are difficult. Not much we can do. So typically what I'll tell people is if we have savings bonds and they're mature, go ahead, cash them out. They're not super easy to deal with upon passing. If we have outside stock, same thing, whether it's we own it jointly with someone, we put beneficiaries on it, or if we own it individually, again, put beneficiaries on it. Cryptocurrency, I know that's the new thing. And typically most of those cryptocurrency or Bitcoin accounts, there's been one I've seen that you're able to put beneficiaries on. I know sometimes there's like a disk where you have a passcode, and as long as your family has that passcode, they're able to still handle that. So still learning some more about cryptocurrency. Some you can put beneficiaries on, some you need a passcode. Also, what avoids probate would be what's called a living trust. I'm sure some of you have heard of a trust or have dealt with a trust in your lifetime, whether it's parents or family members. It avoids probate and it remains private. People can still contest a trust, they can still contest a will, but this doesn't have to be filed anywhere like a will does. Terms can go into effect while you're living, and they continue upon your death, or they may go into effect only upon your passing. It kind of just depends on your scenario. It allows the grantor, so the grantor is the creator of the trust, to plan for a spendthrift child, a minor child, and a disabled child. A spendthrift child means a child not good with money. So maybe you want to hold things in trust and disperse things at certain ages, or maybe so much every quarter in a year, or so much annually or monthly, or whatever the case might be, you're able to do that within a trust. Other reasons I would suggest a trust would be if we have a blended family, if we want to be super detailed within the terms of our trust, if we have wealth planning concerns, and by that I mean federal estate tax purposes. So with federal estate taxes, the limit right now is $13.7 million per person, so not many people are over that. But if you were, then we might consider doing an irrevocable life insurance trust, which I'm sure Joel can talk about life insurance, or he's going to talk about life insurance, but he might be able to touch more on that subject as well. And then obviously a Medicaid Asset Protection Trust, which is an irrevocable trust. Irrevocable trust, I could talk about all day. I could have, and I'm certain we'll probably have a seminar on that at some point. But those are really to start the 5-year period for Medicaid to preserve our assets for the next generation. So really, when I say let's do a trust, it's for one of these reasons. An example of a detailed trust, I'll give you my husband and I's trust, kind of what we have in ours, to give you an example of what all you can do within a trust. So within our trust, we've got a 3.5-year-old and we have an almost 1-year-old. So we have a farm. So in our trust, we said that our guardians of our kids have the right to live in our house rent-free, but they have to pay for taxes, insurance, maintenance, and upkeep until our kids are 20, at which point they would receive our real estate outside of trust. So it would go from trust to them in their personal names. If in the event our guardians do not wish to live in our house, they are to rent out our house, our pasture, our tillable acreage to produce income for our kids. Now, a trust has a high income tax rate. So in the event a trust makes more than $14,400 and that stays in trust per year, that is taxed at the highest personal tax rate, which is 37%. So in order to avoid that, I have in my trust that any income produced, it pays expenses. If anything's left, it flows out to our kids' custodial accounts. In Ohio, a custodial account can be open anywhere from ages 18 to 25. Typically, most banks will go with age 21. I've only found one bank who will go to age 25 around me. So then they would get whatever money's in those accounts at age 21. Then anything else within that trust, so like life insurance proceeds or retirement or whatever the case might be, any liquid funds obviously would pay for their expenses. It could be health, education, maintenance, welfare, clothes, food, whatever the case might be. But then at age, I think my husband and I set it up at age 25, 30, and 35, they would get a 1/3 share of their, overall distribution to then kind of do with what they want, whether it's buy a house, hopefully, do something productive. But they're able to do that at that point. It's kind of like a bonus, say, here you go, spend it wisely. So that's just an example of a very detailed trust that you're able to set up. Okay, I'm going to stop there. Is there any questions so far? Or Michelle, do you just want to wait till the very end for questions?
I think our online viewing they're all muted. So maybe we should wait till the end to ask questions.
Okay, perfect. All right, so now I'm going to run through some scenarios with you. All right, so first scenario. Sally dies, has a validly executed last will and testament. Sally has no beneficiary designations. Sally has a husband, Paul, and one biological child. That child is not Paul's. So Sally's last will and testament states everything is to be distributed to her husband, Paul. What happens to Sally's things? This one's an easy one. Everything would go pursuant to Sally's last will and testament, which says everything to Paul. Next one, so Sally dies intestate without a last will and testament. Same fact, she's married to Paul, has one bio child. That child is not Paul's. At the time of death, Sally only owns a bank account with a balance of $100,000 and a vehicle worth $5,000. Sally has no beneficiary designations, which means no TOD, no POD. What happens to Sally's things? So in this scenario, let's see. Some would go to husband. Let's see. Oh, hold on. I just skipped. Okay, right here. Vehicle would go to Paul because it doesn't have to go through probate. So the vehicle's worth $65,000. He can take her death certificate in, get it transferred over into her name. The $100,000 bank account would go pursuant to the descent and distribution statute, pursuant to Ohio Revised Code. So what would happen would be Paul would get the first $20,000, and then another $40,000 would go to Paul, and then the remainder would be split. Half of the remainder of the state biological child would get $40,000. So basically, Paul gets 60, bio child gets 40. And that's because that child is not biologically Paul's. If in fact that child was biologically Paul's, then Paul would get everything pursuant to revised code. Next scenario, Sally dies intestate and only owns real estate as tenants in common with her husband. So remember survivorship, me talking about survivorship and how important it is. So Sally dies without a last will and testament and owns her residence as tenants in common with Paul. Same fact, she has one biological child. It's not Paul's. She has POD and TOD on all other assets. What happens to Sally's real estate? So Paul might get lucky. in the sense that house would go to him pursuant to revised code, depending on value. So he would get what's called a spousal allowance, and if that house is valued more than that spousal allowance under revised code, he would have to pay biological child some portion of that value. But ultimately, that's considered the mansion house, and it would go to him. All right, now we're going to talk about some powers of attorneys. So Sally is in a car accident and does not have a financial power of attorney or a healthcare power of attorney. She's married to Paul, has one biological child. She's got a long road to recovery, will need to be admitted to a rehab facility and potentially long-term care facility. Sally and Paul have all separate finances. Sally's bills need to be paid. Who has the authority to make these decisions and pay bills for Sally? So it just depends. So she would have to get a court guardianship. So someone would have to petition the court, be Sally's guardian for both medical and financial. And then it would be up to the court who decides or who is appointed to make decisions, healthcare and financially. And then same scenario, she's in an accident, she's executed a valid financial POA and healthcare POA. Same facts, married, has a biological child, her bills need paid. She's appointed Paul as her healthcare power of attorney, and she's appointed her biological child as her financial. So who has authority to make health decisions for Sally, and who has authority to pay bills? So for healthcare, she's appointed Paul in her healthcare POA, no need for court. And in her financial POA, she has appointed her son or biological child. So he or she, I want to keep saying he, I guess, since I'm thinking about my son right now. But that kid would have the authority to pay bills for Sally. Okay, and then this one, so Sally is on a ventilator, has executed a healthcare POA and living will. Same facts, married, has biological child. She has appointed Paul as her healthcare POA. Paul wishes to keep her on a ventilator for 2 more days, but she has a living will. So can Paul make this decision? The answer is no, because that living will overrides Paul. Again, living will always overrides healthcare POA. So if it's your intent that your agent in your healthcare POA makes that final decision, my answer to you is do not execute a living will. However, if you want to take that authority or that decision off of their shoulders and just you make that decision for yourself, you need to execute a living will. So because I'm an attorney, I'm going to have a disclaimer. So obviously this is very general information. Everyone's fact scenario is different. So, legal advice will vary depending on your specific needs, goals, assets, anything like that. So that is it, Michelle.
Awesome, Nicole. That was very eye-opening, at least for me. Alrighty. Next, I will go ahead and ask Joel if he would like to present.
Yep, happy to jump in here. Let me know if you can see this.
We can see it.
Great. Well, thanks everyone for having me. My name's Joel Harvey. I work for a company called Ash Brokerage, which we help a lot with education when it comes to insurance products and protecting the estate that you've worked so hard to build and the retirement income that you've worked so hard to build. We focus a lot on efficiently transferring wealth. We do all of that through different insurance products, whether it's long-term care and life insurance. Those are the 2 big ones that we're going to talk about today. But appreciate you having me. I've been in the industry for about 8 years now. Work with a lot of folks across the state of Ohio, but also get down to Miami and Manhattan, New York, and travel across the country for the most part if I need to, and do a lot of different presentations similar to the one that we're talking about today. So what I'll discuss is, talk a little bit about where the long-term care industry is today, why it's important to help educate folks like yourself on what's out there, some of the emotional, the logistical, and the financial challenges that I see people encounter when they're talking about long-term care, what it looks like, what it means to design a plan, and more importantly, and probably the most important conversation out of that is how to receive the benefits from a long-term care policy. Once I get through that, I will focus on efficient wealth transfer. So leveraging dollars that you currently have to pass on to the next generation, and repurposing, maybe some idle assets that you have to get some additional leverage using life insurance policies. So to start, just a little bit of an overview of the long-term care industry. I'll get to these numbers in a second, but we're seeing a large uptick in the amount of long-term care policies that people are interested in. It's been amazing to me as I've been on the forefront of some of these conversations. Is not only is it driven by advisors and financial advisors that we have the pleasure of working with to present to their clients, but also by clients of the credit union. And that's been an interesting piece where you all are the ones that are bringing the conversation to the table. And the reason that I'm seeing more of that is just some of the costs of care that we're seeing in the country, whether it's somebody who's receiving home care or somebody who's receiving care in a nursing home or an assisted living facility. I think inflation on those different metrics has been around the 8 to 10% range number over the course of the last 4 years. So we're hoping that obviously that slows down, but that's a big change in 4 years. And that's why we're seeing more and more people do planning to make sure that they have the funds to be able to pay for that cost. One of the reasons with that cost that we're seeing people do planning is you've done such a good job saving for retirement throughout the course of your life. And one of the biggest threats to those retirement assets and to that nest egg that you've accumulated is some form of a long-term care event. Nicole did a great job of talking to us and educating us on what we should do with the different assets we have and make sure that we're efficiently transferring them to the next generation and avoiding probate. This is the other side of the conversation of how can we protect it while we're still alive. So to get into some of the claim numbers for long-term care, when we look at paid claims from the industry, this number is continuing to increase. We don't have the 2024 data yet, but as of 2023, over $14 billion of claims were paid out, which is just a staggering number. Another fun stat that we talk about is where do claims start? 56% of the population over age 65 will need some form of long-term care. And 73% of those claims will start in the home. And I think, this is a big misconception that I run into when I'm helping Kelly and we're talking to folks like yourself about long-term care planning and solutions. A lot of people think that long-term care is something that only happens when I go to a nursing home, right? It's, I have this policy and it's going to help pay the nursing home and that's great. And that's all it is. Well, long-term care can be also used to fund home care. And I think that's, yeah.
Are you still on the first slide or have you moved on?
I have moved on.
Okay, all we're seeing is the first slide at this point.
Oh, interesting. Okay. Give me 1 second. I'll try to stop sharing and then go back. Is it moving at all now?
We're not seeing your screen at this point.
Oh, weird. Okay. Sorry, it was moving.
I had to not do like the actual presentation. I just had to click through the slides.
Got it. Okay. Thank you for letting me know. Is this moving?
Yeah.
That's moving? Okay, great.
Thank you.
Yeah, no, thanks for letting me know. Sorry about that. So as I was saying, here's kind of like that graphic of how much has been paid in long-term care claims. You see that staggering $14.1 billion, and then where claims start. So this is the number I was referring to. That's about that 73% starts starts in the home. And from a home care standpoint, that's something that we try to do a great job of educating folks on. Is you can still access long-term care dollars from the policy that you paid into in the space that you want to receive care, which for most of us, 73% of Americans, is at their home. And the way that you access some of those dollars is they refer to them to the activities of daily living. If you aren't able to accomplish 2 out of the 6, then that is when we can start activating our long-term care policy. And I'll get into that a little bit later in my presentation. But some of the things that we think about when we talk about long-term care is, and I try to do the best I can of helping to help educate on, is it doesn't always mean that it's an insurance policy. There's plenty of solutions out there of how we can help pay for this. Some people, they decide that they want to self-insure. Some people use long-term care. Some people say that my spouse is going to take care of me, or my kids are going to take care of me. And one thing that I just encourage everybody on the call to think of is all these three different levers when it comes to long-term care planning. And it's, the emotional side. Anybody who's been through this or is taking care of a parent or taking care of a family member who's not able to perform 2 of the 6 ADLs is, it becomes about a full-time job. There's a huge emotional toll that can be taken, whether it's, family members who are across the country, how are they dividing up that work? Who's doing the day-to-day. It can be tiresome. And I'm sure some of you have experienced that. And then, there's the logistical side of, if we do have folks who are living across the country, family members, how are we handling that? Who's taking care of who? You got to sometimes build a different schedule around how we're helping to provide care for the ones that are taking care of that person. And lastly, the financial impact of, what does this mean for us to pay somebody to come into the home, if we're paying out of pocket, or if we have to use different assets to dwindle down, like our retirement income. Are we paying taxes on that to be able to take care of our family members? The bonus of some of the insurance policies is, thank you to the government for allowing us to have tax-free benefits that come from our long-term care policies. From dollars that we've put in, dollars are coming out tax-free to be able to pay for some of that care. When we talk about designing a plan for you, you'll start with Kelly and the team at Ohio Catholic to work through this. But some of the key questions that we like to understand when we're designing coverage and putting insurance policies together is, what are we protecting? Is there anything in the family like dementia that we should be aware about, that we should be aware of? How are we helping to fund the plan? And we can be creative and help you brainstorm, but there's plenty of different options out there depending on your situation, whether it's maybe a single premium or looking at something that you pay over the course of your life. Different types of funding strategies exist out there in the form of paying from cash, or, paying from a life insurance policy that you might have that has cash value inside of it, non-qualified annuities. Sometimes qualified accounts can make sense. And then lastly, how do you want to receive your benefits? There's reimbursement benefits where the insurance companies will actually write a check to the place that you are receiving care, and that's how it'll be paid, but it's only for that specific amount that you need coverage for. Or there's an indemnity style where they're going to write you a check for whatever amount the policy is letting you have access to. And we can dive into the weeds off the call of what that specifically means. But just know when you are planning, there's not just one specific way to do it. We can be very flexible in the plan that we put together for you that depends on your current situation. The last piece that I'll get into here, because I want to save some time for questions for both myself and for Nicole, is just when we're talking about the estate, a lot of times we're talking to folks who might still have money left over after they pass away. And one of the things that we want to make sure that we're clear on and help educate on is, how can we make those dollars once you've passed away be as efficient as possible? Sometimes the answer is life insurance. Sometimes it is not. But from an insurance standpoint, from our point of view, assuming good health and some of the other factors that go into life insurance planning, there's a few things that we should consider. Just really understanding and working with you on what is your why. What do you want your legacy to be? When we talk to families, sometimes their big focus is, I want to be able to provide my kids with money that I've been able to accumulate, and a life insurance policy can be a good option for that. Other people I work with say, I came from nothing and my kids are going to get nothing, but I'm really charitably inclined. So I want to make sure that the charity of my choice gets as much money as that I can give them. That's a big area that I do work in. And then sometimes I'll see different types of estate equalization strategies, which I see in the form of working with business owners. If they have 3 kids, maybe one of the kids is going to go into the family business, and they're going to take over that business as an asset. And the other kids don't have much else. So, we can equalize the opportunity for the kids by a life insurance policy. So, the next question, and I kind of touched on it, is just who are we doing planning for? Who are we wanting to receive the money? And the transfer of wealth that can occur just by using life insurance can be tremendous, whether it's held inside of a trust or held outside of a trust. There's a handful of different levers that we can pull, but it is an important option. It's an important option to consider inside of the financial plan. And lastly, when we're talking about assets and we're talking about transferring assets, it's always important to remember that life insurance comes back in the form of cash, and it comes back tax-free, assuming that we've structured it the right way. And the reason I bring that up is there are other assets out there that can be taxed as you're passing them from generation to generation. So sometimes we can look at some assets and assist with qualified funds, or if you're starting to take RMDs, or maybe you have existing life insurance policies that you have in force, and you just want us to review them. We can assist with all of that and see how we can maximize the dollars that you have and passing them from your generation to generation 2 or to charity of your choice, or what have you. But we can assist in a lot of different areas of repurposing assets to make sure that that's working as efficiently as possible. And the last thing I'll leave you with is the life insurance reviews. I've been doing this, like I said, for 8 to 9 years. And one of the things that I've realized about being in this industry for some time is oftentimes people forget to do reviews on their life insurance. They will review their financial plan and they'll know, I had SoFi stock last year and it went up 10%, or, whatever it was, or Tesla, or they know what's going on there. But it's also important to review that life insurance and your insurance portfolio. And Kelly and the team can help with putting together some different options of, this is your insurance portfolio now. This is where it's headed. This is what we should be looking at. And, more importantly, is this still doing what you bought it for to do? So if you're curious about where you're at or want to have a conversation of what you currently have, Kelly and the team can assist you with that as well. And with that, I will wrap up. Like I said, once again, for having me, and welcome any questions that you all have. Michelle, I will kick it back over to you.
Thank you very much, Joel. Go ahead. So I do want to open up this now to the Q&A, just if anyone had any questions. You can definitely chime in, either raise your hand to ask either Joel or Nicole a specific question. There is a react button if you want to raise your hand, and I can pull you up. Oh, okay, good. Sir, go ahead and ask your question.
Hey, Nicole?
Okay.
Yep, I hear you.
Nicole, I have a question on savings accounts at the credit union. So you can have a beneficiary, correct, as you mentioned?
Correct.
Is the secondary benefit, are they contingent, or let's say, here's a scenario, you had a mother, father, children, the good Lord called the father, the mother's the beneficiary of the savings account, and the children are they contingent, or will the money go to the children upon the passing of the mother?
Okay, so it depends on the bank. So I know some banks don't allow secondary or contingent beneficiaries. So when I'm talking about primary beneficiaries, I'm talking about if you pass, here's who it's going to first. And then whoever you list, let's say we're going to run a spouse situation. So say it's husband's account, he lists wife first, and then it's contingent to the kids. If wife or husband and wife pass together, then it would go to the contingent beneficiary, so to the kids.
Correct. So that okay. So they are contingent. Then okay. I understand that.
Okay, yeah, we have a couple of questions here in the lobby, Nicole. Or Joel.
Can you talk about the appropriate time to convert from a revocable to an irrevocable trust? And what restrictions the irrevocable trust would create for you if you currently have a revocable?
Yep. So the whole purpose of an irrevocable trust is for Medicaid asset protection. So I guess I'll say my sweet spot for transferring that would be between 50 and 70. And then as far as like implications, you really have to think about tax implications. So if it's like your primary residence, if you plan on selling your home within the next, 5, 10 years, 15 years after transferring it into this irrevocable trust, I'm going to heed you to not do that, to not transfer it to that trust, because you're going to lose out on your capital gains exemption. So let's say we've got a couple or a single situation, your capital gains tax would be, quote unquote, free. You wouldn't have to pay capital gains tax on the first $250,000 on the difference between the sale price and your cost value. So whatever you bought the place for. So the rule is it has to be your primary residence 2 out of the last 5 years, and you have to be the record owner. Well, when you put it into an irrevocable trust, you're giving up control. You're no longer the record owner. The trustee is. So if, that could be your child. So that would be one implication. Number 2 implication is the fact that you're giving up control. So you no longer control that asset. Let's say you do put your real estate into that asset and you want to sell it. Or, you want to say it's vacant land or it's a rental property, and you want to do something with it. Well, you don't have that option anymore. It is entirely up to your trustee. You are the beneficiary of the income of that trust, so it doesn't pick up that high tax rate. But of the principal, you are not the beneficiary. It would be your children or whoever you list as beneficiaries would be the lifetime beneficiaries and the death beneficiaries, because Medicaid wants to see that you no longer have control of your assets. Another implication could be a step up in basis, or I guess the lack thereof. So when you pass and if you transfer real estate to your kids via a revocable trust or a transfer on death designation affidavit, they are going to receive your date of death value. In an irrevocable trust, they certainly can still do that. However, we have to put certain language in that trust to account for that. Medicaid could come back and say, you ultimately had control of your asset, so they don't want you, or they're going to claw that back. I've never seen that happen. I've never had colleagues who have practiced in this area for many years see that happen, but it is a possibility. So it's a risk that you take by putting in that language to allow for a step up in basis. I think that answers your question. So those would be really all the biggest implications of an irrevocable trust is tax implications, lack of control over your asset. You're only the beneficiary of the income of that trust. And then the time period would be anywhere from 50 to 70, in my opinion.
So just as a follow-up, I guess I'm just a little confused. I thought that the purpose of the irrevocable trust was to put your real estate asset in to protect you from Medicaid. But it sounds like what you had said is that you wouldn't want to put your primary residence in there.
So you're correct. It is mostly used for real estate. However, if you go to sell your real estate, then I would not put it in there because you're going to lose on your capital gains. So let's say you've got a home and you sell it within the next 5 years, and then you say, okay, this is my forever home. I'm not selling it. I'm going to die here. This is it. Then I would say, okay, yeah, it makes sense to put that in an irrevocable trust because now we don't have any tax implications as far as capital gains goes. And then as far as the step up in basis for your kids, it's still an avenue. In my opinion, irrevocable trust for long-term care planning is going to be my last ditch effort. I'm going to push the client to somewhere else. Whether it's Joel for long-term care life insurance, that hybrid, that's what I prefer the client to get if they can afford it. If not, then I'm going to say, okay, if this is still a concern, then we can do the irrevocable trust. It's just going to be my last pick to do so.
Thank you.
Any other questions from the lobby?
Do you have any questions, sir?
Okay.
Hey, I got it. Hey, Joe? You there, Joe?
I'm here.
Hey, could you just touch real quick on the living benefits on life insurance, how they can help pay for health care and possibly long-term care? A lot of folks are not aware of the living benefits in today's world. I've unfortunately experienced it with a few clients, and it had a positive impact on helping them receive the care tax-free.
Yeah, sure. So Kelly's referring to living benefits on a life insurance policy that can come in handy whenever you're in the time of need. So there's a few that we see commonly. One is a chronic illness rider. It's similar to a long-term care rider, but if you are not able to complete 2 of the 6 ADLs, or activities of daily living, you can access your death benefit early. And the way you access that is if you cannot perform eating, bathing, using the restroom, getting dressed, transferring, or continence by yourself without needing anybody's support. If you can't do 2 of those 6, then you can start to access the death benefit before you pass away. Sometimes we think of life insurance and we think of it just as something that happens after we've passed away. This is something where it can be a benefit to you while you're still living.
Could you touch on the taxable consequence of that expedited life insurance?
Yep. If you're expediting the life insurance, it's still coming to you in the form of a tax-free benefit. So you've put money into it. You might have these events that have occurred or happened to you. You still get that influx of cash tax-free while you're still living.
And I just want to share this with the folks. 2014, I was working with a client and she's still here. Unfortunately, she just had a stroke 2 weeks ago, and she purchased a policy off me in some other planning. And I talked to her son. He was not aware of this, but she's going to activate her life insurance. He's going to receive. She is for her well-being a check for $80,000 to help her at home. When she comes home, pay for her care. And I've seen that happen over the years. I've seen those scenarios happen often. And again, there's life insurance is just to pass away; it's for the living too.
Is that the total value of the life?
No, this total value it's 200,000 was the death benefit, and then she met the requirements due to her health, and they activated 40% of the life insurance and that's the most that they're allowed to activate for that policy. But, you know, she has other assets, but, you know, that's money that's tax-free that she can use for her care.
That's important to look at that percentage.
Yeah, so there's different policies with different stages for our age, you know, how much is gonna be activated, if it's a chronic illness or if it's a terminal case. There's just different numbers with different providers, different carriers of insurance. So if I was, you know, working with someone, I would make sure they understood what's the benefit, what's the advantage, what's the amounts paid out, et cetera. I just think as an advisor that, you know, your checks and balances, it's not to push products, but it's something that if it's the right thing for the credit union member, it can be beneficial, you know, if that's part of the game plan. Because at the end of the day, you know, if we have issues that come up with health, we're going to have to self-pay before we get some assistance, or, you know, we might exceed our insurance, etc. So.
Perfect. Any other questions from the group? All right, Joel or Nicole, do either one of you have any like final thoughts or points that you wanted to drive home before we end?
I just asked the check for everybody.
Oh,
So
thanks.
it'd be good to.
Nothing from mine, Michelle. Appreciate the time. Appreciate you having us. And if there's any further questions that come up, feel free to direct all those to Kelly, and we can work from there.
And Michelle.
And Michelle.
Thank you. Can't get one without the other.
That's right.
So just, and Nicole, is there anything else you wanted to share?
No, not really, Michelle. Just, I guess I would drive home the fact that estate planning is something that you really shouldn't put off. Here recently, I've had a lot of people come into my office with very serious illnesses, and the only reason they're getting their estate plan put in order is because they're sick, and it just adds so much more stress on you, on your family members. So, you know, if you're attending this seminar and you don't have an estate plan in place or haven't had one, you know, revisited for many years, I would say now is the time to do it, instead of putting that on the back burner continuously. And I appreciate you guys having me and speaking to you all.
Definitely agreed. Thank you, Nicole. Appreciate all your time, and Joel as well. Appreciate all your time this evening. Both Kelly and myself are available. We do share the same phone number as we are OC Financial, 216-518-7270. You can give us a call, and our emails are also on the screen. So if you have any questions or concerns or want any further information, we can get you in contact directly or answer any of those additional questions you may have.